finds that the aggravating factors substantially outweigh the mitigating circumstances and sufficiently warrant a sentence of death in this case. Therefore, the court finds that the sentence of death is the appropriate penalty the court should impose for the murder of 9-year-old Felicia Williams, as charged in count 1 of the indictment. Accordingly, as to count 1, for the first-degree murder of Felicia Williams, the defendant, Granville-Ritchie, is hereby sentenced to death. Defendant shall be delivered into the custody of the Florida Department of Corrections at the Florida State Prison, where he shall be confined until a date certain selected by the governor of the state of Florida, and on that date, defendant shall be executed in a method provided for by the laws of the state of Florida. As to count 2, for the sexual battery of a victim less than 12 years of age by a defendant over the age of 18 committed against 9-year-old Felicia Williams, defendant shall be sentenced to life in prison without the possibility of parole. As to count 3, for the aggravated child abuse of Felicia Williams, defendant shall be sentenced to 30 years imprisonment. Counts 1, 2, and 3 shall run consecutively to each other. However, the 2 cases you pled to earlier today will run concurrent with count 1. Defendant is hereby notified that this sentence is subject to automatic review by the Supreme Court of Florida. Counsel will be appointed by separate order to represent defendant for that purpose. Further, pursuant to section 922.105 Florida statutes, defendant has 30 days from the issuance of a mandate from the Supreme Court of Florida affirming the sentence of death to elect death by electrocution by the procedures required by law. Mr. Richie, I do have one final thing to say to you. There will be no corporal redemption for you. And what I mean by that is of your physical being, your person. You will remain incarcerated until the date of your death is scheduled to occur. However, I do not know what your spiritual leanings are, and it really does not matter to me either way. I am very grateful that I live in a country where people can believe or disbelieve anything they choose, and that applies to you equally. However, if you do ever pray to a higher power, either now or at some point before the date of your death is scheduled to occur, and you truly seek forgiveness and redemption for the sins and the crimes you have committed, I hope that you are granted it. And I do still see the humanity in you. May God have mercy on your soul, Mr. Richie. We are now concluded, other than I am going to read the note that I received that was unsealed, or that was sealed. I'm now going to unseal it. And it is a card, and it says, "I thank God as I remember you." 2 Timothy 1:3, and it's from the family of Felicia Williams, and it's a photograph of Felicia, aka Sugar Plum. And I wish to thank you all for this. God bless all of you. Thank you very much. We're now concluded.
Hi, my name is Dee, and you're watching Dee True Crime Commentary. This is what happens to people who hurt children. Granville-Ritchie got 30 years, a life sentence, plus the death penalty for killing Felicia Williams. These are the kind of crimes where the sentences are just stacked up on top of each other. This is also how the summer case will be and should be. Sentences stacked on top of each other. Now, on to the next one.
Or did you, when Megan came back to live with you, was she working? Did you help her out? How'd she support herself?
I supported her.
Okay.
I supported her when she was with them people.
All right.
Bought her whatever she needed and give her money and stuff.
Okay. Well, tell the jury, 'cause we don't know what sorts of things did you do to help her out?
I give her money. She had my credit card number. She'd get stuff on it. I mean, if she needed anything, the baby needed anything, I seen to it they had it.
Judge, I think General Massey was on her way back. Judge, but we approached.
Determining the appropriate sentence for these offenses, the court has considered the evidence presented at the trial at this sentencing hearing, pre-sentence report filed April 4th, 2025, more than 10 days ago. The principles of sentencing and arguments made as sentencing alternatives, the nature and characteristics of the criminal conduct involved, the evidence and information offered by the parties on mitigating and enhancing factors, any statistical information provided by the administrative officer of the courts as to sentencing practices for similar offenses in Tennessee, located at www.tncourts.gov, and any statement the defendant has made on her own behalf about sentencing and the defendant's potential for rehabilitation or treatment. I'm not sure if it was agreed, but the defendant's a range 1 standard offender under Tennessee felony classification laws. And what that means, the aggravated child abuse and neglect charges are Class A felonies, and as a range 1 offender, those would carry somewhere between 15 and 25 years. The tampering with evidence is a Class C felony. The range would be between 3 and 6 years. False reports are Class D felonies, with the range 1 being 2 to 4 years. The abuse of a corpse is a Class E felony, and failure to report death under suspicious, unusual, or unnatural circumstances, also a Class E felony. Those Class E felonies for range 1 would be a range of 1 to 2 years. In determining where the appropriate sentence should be within that range, while not mandatory any longer, the enhancement factors and the mitigating factors are advisory for the court. The state has urged in its filing state's urged number 3, enhancing factor 3, that the offense involves more than one victim. I think it could be made, but I'm not going to find that enhancing factor number 3 applies. Enhancing factor number 4 is urged by the state. A victim of the offense was particularly vulnerable because of age, physical or mental disability. I think that will apply. Testimony was that baby Evelyn was, everybody keeps saying 15 months old. I think she was 15 months old when she was found. My recollection of proof was that she was approximately 13 months old when she went missing. Is that wrong?
She was, her approximate age at death was 15 months old.
At death?
At death.
Okay. So she was 15 months old.
Months old. They assumed when she was reported. When they didn't know she was alive or dead.
Okay. So at the time of her death, she was somewhere between 13 and 15.
Yes.
The state has, the court accepts enhancing factor number 4. Number 5 is urged by the state. The defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. I don't know, and I'm not going to sit here all day and regurgitate the facts from the 11-day trial. But thinking back on the proof that I heard, there can be no more cruel act than to stuff a 13 to 15-month-old baby wrapped in blankets and aluminum foil head first into the trash can. Especially when that 13 to 15-month-old baby was your baby. Number 6, the personal injuries inflicted upon or amount of damage to the property was particularly great. The court accepts number 6. There's no greater injury that you can inflict on another human being than death. Enhancing factor 10 was in the filing. The defendant had no hesitation about committing a crime when the risk of human life was high. The court accepts number 10. Private trust. And again, the relationship between mother and child, there can be no greater private trust on this earth than that. So the court accepts number 14. Those are all the enhancing factors that were urged, all the ones that the court, after having looked through them, believes applies. I'm not going to read all of these in. The defense didn't put any arguments forward as to any mitigating factors that should apply. The court, though, was required on its own, after having read the pre-sentence report, heard the proof, to apply any factors I think are applicable. So there's at least one that could be applicable, and I'm going to talk about it for a moment. that the defendant, because of youth or old age, lacked substantial judgment in committing the offense. The proof is that she was 18 when the killing occurred. But I also have to look at, so there's no question that she was a young adult. But I also have to look at all the other proof and circumstances surrounding the case. And it became very clear to the court upon hearing the evidence that the defendant, in her mind, saw a chance to lead a different life than what she thought she was going to be leading. And quite frankly, circumstantially, from all the proof, baby Evelyn was a stumbling block to leading that life. So she made the decision to remove that stumbling block. And because that's the tenor of the proof that this court heard, I reject mitigating factor number 6. She exercised judgment. It wasn't good judgment, but she exercised judgment in doing the things that she did. So of the 12 statutory mitigators, the court doesn't find that any are applicable to this case. The 13th is any other factor consistent with the purposes of the chapter. And courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing hearing. When the court weighs the enhancing factors and the mitigating factors, that's how I arrive at or not a verdict, but a sentence. I want to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So if the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs, and quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity for those 2 counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight to the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion in counts 4 and 5 that the sentence should be 25 years. The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court, and that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements, about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of a child. So counts 7 through 17 all merge into one count. So they all merge, counts 8 through 17 merge into count 7. In count 19, the courts of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the courts of the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. In the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And of course, ruling, I just so clarify, it wasn't a mistake, but at the time it was filed, I believe we would have all the false report counts filed as criminal history. Obviously, since the court's stronger, multiplicitous, that doesn't exist anymore, so we're not relying on that.
The court rejection. But the court also relies on enhancer number 4 from the same statute, 40-35-115, that the defendant is a dangerous offender whose behavior indicates little or no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But as pointed out in State versus Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the main case is the Wilkerson case, 905 Southwest 2nd. (933) Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 40-35-115 enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that consecutive sentencing is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So, from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was that that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first. There's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake, a lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravated. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child, the court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart. And then, would the aggregate length of the sentence reasonably relate to the offense which she stands convicted? For the same reasons I've just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 It's found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for new trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, share, I'll do it.
Judge, I would also like to have this sentencing period as well.
Sentencing here will need to be typed up as well. We'll set this for status. We'll send Ms. Boswell back to TDOC. And let's set this for a status on January 16th to see where we are on getting the transcript prepared.
That's fine. Can I waive Ms. Boswell's appearance at that?
Well, what I prefer her to do is appear by Zoom.
That's fine.
If she can, but if not, yes, we'll do whatever.
Okay.
All right. All right, that's all.
I don't know what y'all think about it, but I think Goodwin is the best judge I've ever seen anywhere in any state. Tennessee, Florida, he is the best judge I've ever seen. In the Summer Wells case, we'd be so lucky to have a man like him. When it comes down. Thank you for watching. Please like, subscribe, and share. And I'll see y'all later.